As you can see, I have tweaked Maddie's sign again to say justice now. Because right now I'm feeling a little bit frustrated. Now, we knew this was coming, but when I went in this morning to look on the court website for a particular document I was after, there was a new motion filed, and you guessed it, it is a joint motion for a continuance, meaning this is coming from both sides, which I'm kind of disappointed over. Right now, I can't tell you the reasoning behind it because that document actually hasn't been made available online yet. But it appears that we have a motion to continue, meaning that there's probably a good chance that we won't be looking at pre-trial next week. Now, I know that Judge Carsten has been pretty firm about continuances and has implied that there won't be any more continuances, but I'm thinking if it's coming from both sides that probably he doesn't have much of a choice, and unless it is something somewhat frivolous, he will have to grant a continuance. So as soon as that document drops, I will hop online and give you an update as to what it is that is being requested specifically. Meanwhile, the defence aren't done with filing motions. Now, I don't know if this latest motion is a new attempt at censorship, whether it is a fair call, or whether it is strategy in terms of setting the stage for appeals after a conviction. So, this latest motion is a motion to have all newspapers removed from the courthouse. So this motion has been filed by Alex Johnson, the male attorney that you've seen at the various proceedings that we've had so far. And his allegations are that basically newspapers are being put in locations where the jury is going to see them. So I'm going to read through the document and I'm going to just share my thoughts on this as we go through it and also at the end. So this is definitely something where I'm going to be very interested to hear your thoughts and opinions. So this is defendant's motion to remove newspapers from courthouse during pendency of proceedings. Okay, before I start, I should probably mention I'm probably just super aware of it and maybe it doesn't show, but I have a split lip at the moment thanks to snuggling in bed with the chihuahuas this morning. One of them was asleep on the pillow and I had a delivery at the front door and she ran straight over my face. So if I do sound like I am talking a little bit funny today, that is why. Okay, let's keep going with this motion. The defendant, Stephen Stearns, is charged with 8 counts of battery on child under 5. 5 on child under. Yeah. Good work. We're in the first paragraph and they can't even get it grammatically correct. They're missing words already. 5 counts of SB with a child 12 to 18, familial custodial authority. 7 counts of that one. And 40 counts of unlawful possession of materials depicting stuff. Or more, with 10 or more images. So each count basically applies to him having possession of 10 or more images. And there's 40 counts of, which means there's at least 400 images that they are talking about here. Which, yes, we know it's actually several thousand. But just wanted to emphasise that before we get into this motion, because it seems that the defence team have forgotten precisely who it is that they are representing in the first place. This case has garnered extensive media coverage throughout Osceola County and the surrounding areas, with developments in the case consistently making front-page headlines in local newspapers, including but not limited to the Osceola News-Gazette. These newspapers are currently made available in public areas of the courthouse, beyond security checkpoints, including the lobby and waiting areas where potential and selected jurors frequently congregate. Now, I have questions about that for starters, because once this trial is on the go, I don't think the jurors are going to be congregating in the lobby or in waiting areas. They will be given their own room. And I'm pretty certain that given the publicity that this case has had, that they will be sequestered. So they're not going to be in public areas. And my question too is, would jurors be entering the courtroom via the lobby? Especially with this case, or would they have a separate entrance? And the other question I have is he referring to something that is quite standard in this courthouse and has therefore not been an issue for other trials because of the particular locations where these print media things have been located? It just seems like a bit of a overreaction to me. Although I can also understand the need to avoid influencing the jury. The Sixth Amendment to the United States Constitution and Article 1, Section 16 of the Florida Constitution guarantee the defendant the right to a fair trial by an impartial jury. In Shepherd v. Maxwell, the United States Supreme Court recognised that courts have an affirmative duty to minimise the effects of prejudicial pretrial publicity. Similarly, in Irwin v. Dowd, the United States Supreme Court held that exposure to prejudicial publicity can violate a defendant's right to a fair trial where it creates a presumption of prejudice that cannot be overcome through voir dire. The Florida Supreme Court has likewise recognised that trial courts must safeguard criminal proceedings from prejudicial outside influences. I don't think that is actually about newspapers in the lobby, but I'll come back to that. Florida Rule of Judicial Administration provides that the presiding judge may authorise broadcasting, recording, photographing or electronic dissemination of judicial proceedings, subject to the authority of the Chief Judge and the limitations imposed by this rule. By logical extension, this rule recognises the court's authority to control media influence within the courthouse. The defendant acknowledges the freedom of speech and press guaranteed by the First Amendment to the United States Constitution and Article I, Section 4 of the Florida Constitution. However, courts have consistently recognised that reasonable restrictions on the time, place and manner of expression are permissible when they serve significant government interests and leave open alternative channels for communication. I think that Will J might have a little bit of a party over this, and I'll come back to that. In Ward v. Rock against racism, the United States Supreme Court held that time, place and manner restrictions are valid provided they are content neutral, narrowly tailored to serve a significant governmental interest, and leave open ample alternative channels for communication. In the instant case, the extensive and ongoing media coverage creates a substantial risk that potential jurors could be exposed to prejudicial information while physically present in the courthouse, the very location where the sanctity of fair trial rights should be most jealously protected. On March 4th, 2025, newspapers were prominently displayed in the courthouse with the headline, "Remembering Maddie," referring to the alleged victim in this case. I know that's just legal wordage that really pisses me off to hear her referred to an alleged victim. Such emotionally charged headlines in the courthouse itself create an atmosphere that substantially prejudices the defendant's right to a fair trial. Now, can we just acknowledge, I'm pretty certain that they weren't prominently displayed in the courthouse. Like, there were display stands holding newspapers so that everyone who walked past had to see them. Or display cabinets with "Remembering Maddie" prominently displayed. Anyway, moving on. Of particular concern is the presence of these newspapers in the jury services room and at security checkpoints where potential jurors must pass through, ensuring their immediate exposure to potentially prejudicial headlines before they even enter the courtroom. Now that one, if that is correct, is a little bit concerning, more than a little bit concerning, because there really shouldn't be newspapers in like a juror's lounge, which presumably that is what they mean by a jury services room. Of course, my question to this allegation that he's making is, was there an ongoing trial at the time? Was that room actually being used by jurors at the time? Because is it not possible that at the time when he saw this newspaper that it may not have been being used by a jury and the newspaper may have been left there by court staff who were reading it on a break, knowing that there wouldn't be jurors in there to see the newspaper? The defence has observed newspapers containing prejudicial headlines in multiple locations throughout the courthouse, creating a pervasive atmosphere that could compromise the impartiality of potential jurors at every stage of their courthouse experience. The requested relief constitutes a reasonable time, place and manner restriction, as it A. is content neutral, applying to all newspapers, regardless of their content. B. is narrowly tailored to serve the significant governmental interest of ensuring a fair trial. C. is limited to specific areas within the courthouse. And D. leaves open ample alternative channels for the press to communicate information about the case. Notably, the request for relief is narrowly tailored and does not seek to restrict the media's right to publish information about the case, nor does it seek to bar members of the public or media from attending proceedings. Rather, it is limited solely to the removal of newspapers from areas of the courthouse where potential and selected jurors are likely to be present. The relief requested is temporary in nature, lasting only through the pendency of these proceedings. The removal of newspapers from the courthouse lobby and waiting areas beyond security checkpoints presents a minimal burden on public access to information while substantially protecting the defendant's constitutional right to a fair trial. This request is consistent with the court's inherent authority to control its premises and ensure the integrity of judicial proceedings. This motion is made in good faith and not for the purposes of delay. Wherefore, the defendant respectfully requests the Honourable Court, the Honourable Judge Carsten, Administrative Circuit Judge for Osceola County Circuit and County Courts, enter an order directing the removal of newspapers from the courthouse lobby and other areas beyond security checkpoints during the pendency of these proceedings, and for such other relief as this court deems just and proper. Okay, so honestly, this motion feels like this lawyer is trying to tell the judge how to suck eggs. I mean, I would imagine that when a trial is in process, that the court does have protocols with regards to where they are actually going to allow newspapers to be left in the courthouse. And I would imagine that there are strict protocols in place that don't allow newspapers to be left in the jury room. So it seems like a somewhat redundant motion to me. I think that what he's citing in terms of statute and constitution is in fact more about people's rights to stage protests and rallies outside the courthouse, and basically saying, they have a right to do so if it is monitored by the court, is in a somewhat neutral location, and is not going to impact on the jury. So I think that those precedents that he's citing are about the courthouse controlling those sort of things, not about the courthouse controlling the existence of newspapers in the court, in the courthouse. I mean, this courthouse has been in existence for who knows how long, and we've not heard any issues before about the existence of newspapers in the courthouse during a trial. So it seems a little bit preposterous. However, if indeed there were newspapers put in the jury room, that would of course be of concern. As for newspapers in lobby areas, etc., places where the public are going to be, like I said, I think this case is going to be one where the jury is going to be sequestered, simply because of the amount of publicity it's already had. So, for starters, the jurors aren't going to be hanging out in the lobby during the trial. But let's look at the normal court processes. Basically, you have voir dire. During the jury selection process, jurors are going to be asked about what information they already have on this case, how much they know about the case, all this sort of thing. So if a juror says, well, I've sat down in the lobby and I read an article that told me everything I need to know about this case and I'm ready to make a decision now, well, of course that juror is not going to be selected. And of course, during the trial, if a juror goes into a public area and picks up a newspaper that has an article about the case, well, they're going to be dismissed, aren't they? So it does seem that this motion is a bit of a joke. Seems like it is slightly unnecessary. And I don't know whether it is just that this lawyer is just trying to flex his muscles a bit. Say, hey, look at me, I'm super efficient, even though, hey, now we're going to put in for a continuance. Or if this is setting the stage for, like I said, for appeal down the track, where they're going to turn around and say, well, we asked for all newspapers to be removed from the courtroom and they weren't. And this is what we're going to appeal on. Like I said, I think they're trying to tell the courthouse how to suck eggs. I'd imagine the courthouse knows where newspapers can and can't be. And I'd imagine that they are going to make sure that jurors do not have ready access to newspapers. I can hardly see someone knocking on the door of the jurors' lounge each morning and going, here's your morning newspaper, people, catch up on the latest on the case. So, yeah, I don't know why they've made this motion in the first place, but it seems a little bit redundant. So I'm keen to hear your views on this. What do you think's going on here? Do you think it is just another excuse for another motion? And I've lost count now. I think we must be heading up to 80 motions. Or do you think it is a legitimate request? So on that note, I'm going to finish there. As soon as the documents are up for this continuance, I will grab hold of them and bring you up to date with that. But in the meantime, thank you for listening. If you are new to my channel, please subscribe. Also, please hit the like button. YouTube loves that, and of course it gets my videos out into the algorithm. And don't forget to leave a comment below. Thank you, and I'll catch you in the next one.